Hey everyone, welcome to another episode of Darshan Talks. I'm here with the one, the only Dan Safara, who runs his own podcast, and Dan's going to tell us more about it. But we're hoping to actually be live on his podcast as well. So, Dan, first off to you.
Hey, thank you. No, I'm not able to restream, but it's okay, Darshan. This is gonna go on your LinkedIn. I'm imagining your YouTube, so
It
I'll
is.
repost. I'll repost it the old-fashioned way. I don't know if it's legal or not, but that's how I'm gonna do it. So yeah, I've been busy, man, running the site. Yuma Clinical Trials. Been busy reading your post. Actually, somebody forwarded me your own post. He's like, I don't know if you know Darshan. Kulkarni. And I said, yeah, of course. I must have missed that post about the FDA audit,
Right.
the 483. The 483. So on the surface, it looked like wow, the FDA is really cracking down hard on this person for like what seems like just maybe some minor deviations. But what it boils down to is no, this PI knew that they were skipping important things and they still chose to do it. It's different than just doing it, but then not really carefully looking at the results. Like we can get into the details, but I feel like the FDA inspector, auditor, whatever you call them, took that into consideration too. Like this person was brazen enough to knowingly ignore several key IE criteria, which is very different than just overlooking like a lab result.
So, I think overall there's been this bump in evaluation of audits and research misconduct, and we're seeing that. I've had multiple PIs reach out to me over the last few months around research misconduct, research fraud issues, and we're seeing larger academic institutions actually take a less tolerant approach to this type of behavior.
Hmm.
So I'm thinking that this is not a um, one-off. I think that there's more coming, and I
Yeah, I don't think
think
it's a
yeah,
one-off either. I think it's a wake-up call for sites
as a wake-up call for PIs. I
for
think
PI. Yeah.
PIs. Uh, we've sort of always operated under this. Yes, PIs are important, but PIs work as part of a team, and that's always been the case, and that's always true. But what is becoming more and more evident is that DOJ, OIG, FDA are all now taking this broader approach, and they're taking the perspective that um, when we say the PI signed 1572, we really mean that the PI is responsible. And what does that mean? It is a little bit of an unfair burden on the PI as I see it, because how does one human being do all those things? I mean, even supervise, there's a limit to what you can supervise.
Right.
But in the end, they're responsible. It's similar to like Europe, where they
But in
have
this,
something called responsible party. So,
but in this warning letter, okay, it looked like the PI was in full control, fully aware of what's happening. It looked like they were the ones actually saying, you know what, like we can't get the salivary flow rate. Like let's just skip it. Like what a good idea. That's different, Darshan. Like I know you're an attorney. You probably
yeah,
say, well, under the law, I mean, we can get into that, but
sure.
being the PI, documenting, hey, this patient cannot produce saliva. Let me give them something so that we can try to get saliva. We still can't. Okay, let's randomize anyways. That's different than a coordinator putting zero point zero 0.09
Right.
salivary flow rate when we need zero point 0.1 inadvertently randomized. Like, I think the FDA's auditors are human beings. They understand intent.
Right.
And I think that played a huge factor in this warning letter because that difference, same issue, but the two different responses to it is the difference between receiving a warning letter and receiving like whatever else they send, right? I don't even know what.
483s or you could be looking at exclusions and everything else.
Yeah. To me, I don't know. Like, that's the way I interpret this.
Right.
And there's also further examples in that warning letter of them doing the same thing with X-rays. Like, oh, we didn't get the X-ray. Let's just randomize them anyways. As opposed to, we got an X-ray. Maybe the positioning wasn't right as per protocol, but someone still gave it a grade, and they got randomized. Like, again, same deviation maybe, but different way that we achieve the deviation. One can be corrected, the other can't, because one is a mentality, the other one's maybe a process error. I'm pretty sure the FDA looked at that like, we're never going to be able to have a kappa plan for a PI that's arrogant enough to do whatever they want, but we can
Right.
have a kappa plan for a coordinator that's, oh, you know what, like, we're off by 0.01, like, our bad, like, we won't do it again.
Right. The thing I've seen when I audit facilities tends to be that they'll just usually brush this under the rug, and then say things like, "Oh, what we're going to do is we're going to just retrain people."
Mm-hmm.
And the problem is retraining, as you're pointing out, is not the solution. It's really, I mean, if you've trained the same PI, the same workforce multiple times,
Well, you
there's
can retrain a process issue. You can't retrain a mentality like of,
yeah,
I'm going to do what I want.
exactly.
And I'm sure the FDA, like the auditor, I want to believe that the auditor would have responded differently had, comparing my two examples. Like, I don't think both of those sites get a warning letter.
No, I don't think they both get a warning letter. I think one might be either a conversation or more likely a 483. The warning letters usually tend to be the situation where it'll be preliminary, and you know what? It's either really bad or you ignored the 483. That those are the general two situations you'll see warning letters. Um, and I'm guessing that if it came to a warning letter in this scenario, it was probably more the PI ignored or didn't escalate or didn't take it as seriously as he or she probably should have.
Right. Yeah, because in this example, they even referenced that the investigator did reply to the warning letter, but it was insufficient
Exactly.
explanation. Now, can you break it down for us, like, for your audience, for mine, uh, the outcomes of a FDA audit at a site, like the potential outcomes? What are, like, how many are there, and then what? Can you just walk us through that?
Absolutely. So there, and it's funny you say that. I'm actually in the middle of writing and doing a podcast on something similar to this. But the key things generally will end up being you might have untitled letters, but before that, you might really just have a conversation. And let's say the FDA auditor comes in and says, "Look, we found these problems, these issues. You really need to focus on." And typically, the site goes, "You're right. We'll make sure we take care of that." Then you might have these issues. I need to write them down because they reflect something that I'm concerned about. I want you to take them seriously. That's your 483.
Oh, so one alternative is you don't get a 483. You
Yeah,
just
one
get like,
alternative is you just have a conversation.
I see. I see.
Um,
But it's documented in some kind of form, no?
no, it's just a conversation. It might be internal records, but
Yeah.
at the actual official level, there's only the written 483.
Okay. Okay.
Then after the 483, you might be in a scenario where the inspector comes in second time or third time and notices that it's the same problems over and over and over again, and they go, "Yeah, this is a warning letter at this point,"
Mm,
or it's something that really compromised patient safety. It's automatically a warning letter at that point. So, for
I see.
example, as you pointed out, you might be in a scenario where um, patients, like people didn't qualify. So your LFTs are through the roof, and you still include the person in your study when that was an exclusion criteria. Well, it's an exclusion criteria not only because it compromises the potential efficacy of the drug, but potential safety of the patient. And you put the patient in, that compromises everything. So that might take you to a warning letter directly. You then might land up in a scenario where you are escalated, and you have a chance to sort of negotiate. You have a chance to sort of tell the FDA your side of the story. But after that, they might say, "We want to exclude you from participating with the FDA. And I've worked with clients like that, where they just go, "You're not allowed to participate any further with the
in
FDA
research.
in research."
Okay.
You might also have a scenario where they say you're not allowed to participate in any business involving a drug company. And I've had scenarios where you go, what does the word involving a drug company mean? Because involving could just mean everything from I'm an employee of the drug company to I'm a contractor of the drug company to I work as a contractor for a contractor for a drug company. So, for example, I sweep floors at PPD. Am I now not allowed to sweep floors at PPD? What if I volunteered to sweep floors at PPD? Is that still a problem?
Well, yeah, I mean, I could see that, but
the funny thing is, I actually had this happen, and I've had sites be shut down because of it.
Sites. So a coordinator basically getting banned from research, or
No, in the one situation, it was a volunteer for a contractor for a site
wow.
who was banned.
So the FDA, it goes beyond just the PIs. They can ban.
Correct.
So how are they banned? They're given a 483 to the individual.
So you don't get what's called a 483. You get what's called excluded. You might have a 5-year exclusion. You might have a permanent exclusion.
Wow, I see. But
Correct.
those are not as common as
Not
warning
as
letters.
no,
Right.
of course not. Of course not. But it happens more often than you think.
Like, can you comment on what were the specifics of this
I can't
individual?
comment on the specifics, no, because that'd be attorney-client privilege issues.
Mm.
But you can find a bunch of them on the FDA website. I'm happy to provide a link, and we can talk through that as
Okay,
well.
yeah. I'd be
Um,
curious to see why in that case the PI was not held responsible for the conduct of the individual.
so it didn't get to the FDA in that specific context. What happened there was a sponsor found out that the site had a um, had a consulting company or contractor that had a volunteer. So we're talking about 4 levels of separation.
Mhm.
And the sponsor terminated the study, reached out to the IRB. And you're
I
just
see.
going, that's ridiculous.
So then the IRB came in, did an audit,
Right.
and then they called or I don't know if you
So the
called.
FDA may have to be involved. The question is, should the FDA be involved? The person who was excluded was not getting paid, was not getting paid by the site, was not getting paid by the consultant to the site. So what exactly are we worried about here?
Yeah. Huh. All right. That's interesting to me. So there's a lot to unpack, I guess, in all this, but in your experiences, these inspectors, they're human being. In
Correct.
many cases, or maybe in all cases, there's like they're given subjective leeway as far as should I issue this 483, should I not? In the example you posted on LinkedIn, which I read,
Mm-hmm.
would you suspect, or maybe but would you suspect that this was a follow-up audit? Because in the letter it said they spent like the entire month at the site.
Yeah.
So like, do you think that PI was given a chance before that was undocumented? Like, hey, you know what? We're gonna audit you again if like this keeps happening, and then it happened. This was like another example. Is that like common for you, or do you think this was like a
So,
one-time 1 month audit? 1 month is insane for an audit.
exactly. So you don't do a 1-month audit unless there was something else that happened in the past.
I
So this
see.
may have been the second audit.
Yeah, okay, that makes sense. Because 1 month is
Yeah.
crazy, man.
You
Even
don't
one.
walk in to do a 1-month audit. If that happens, one of two things happened in that case, right? Either this was a second audit and you knew there were problems the first time or the second time,
Mm.
or you came in and you saw an absolute shit show.
And you give them a chance to say, hey, you know what? I'm gonna come back. Like, if
Well,
these things need to be fixed.
you were there for a month. chances are you've given them lots of chances and you've had lots of conversations.
Wow. That's
You
crazy. 1 month. But in 1 month, they only found like 3 deviations.
no, now remember, those may be the 3 deviations they want to point out.
Okay. So
At the
who
warning
knows what
letter
they
level, you
found?
don't raise everything.
I see. Wow. In those cases, can't the CRA? I know the whole purpose of your post. Well, the whole purpose of my opinion on it was, hey, sites like you shouldn't rely on your CRA
Yeah.
for compliance. Like they're not a free QA person for your site, as we all look at them, as we hope they are, but they're humans as well. But wouldn't the auditor look at the monitoring and say, hey, like you're not off the hook either?
So it's funny you talk about this. So the couple of things that are coming up. One is HHS and ORI basically came out. ORI, for some people who aren't aware, is the Office of Research Integrity. People don't even know, are not even aware that this agency exists.
What do they do?
So look at research integrity, and they are the ones who define things like research misconduct. So I don't know if you saw, I had a thing on Stanford being cited for research misconduct.
I saw something. I didn't look under the hood on that one like I did
Yeah.
on this other one,
Yeah.
but I saw.
So, and I'm not saying this about Stanford specifically, I'm just saying in general. The idea, the proposal that just came out from HHS on redefining research misconduct and the like was, we want, if you guys do audits, we're going to start putting those audit results, even if they're internal, out in public.
Okay.
And that's hugely problematic.
But even if they're not worthy of like warning letters or.
And that's part of the discussions and negotiations and all of that stuff that's going to happen, right?
Yeah, I mean, I don't see anything wrong. They should do that for all sites.
Well, that's fine, but number one, it's not always just going to be the sites. It might be the CROs, it might be the sponsors, there may be confidential information that you're playing with. So this is why people will just go, I'd rather hire an attorney, because you get attorney-client privilege, and that can't be disclosed.
Darshan ain't never going out of business. That's okay. That's the sweet spot for you. Yeah, right. The ORI. It's probably the first time I heard of it. Come to think of it, I know the OHRP, FDA, right. But who like runs all these things? It's just
HHS.
HHS runs all of it.
Yeah, so far everything we've discussed so far is HHS.
Okay.
But what surprises a lot of people, like agencies that you never thought had jurisdiction, U.S. Postal Service has a huge impact on what's being done. So your drugs that are being brought in from India or China, whatever it is, those might be resulting, like, obviously Border Patrol cares about it.
Border Patrol, yeah.
But Customs. USPS is huge. Data that you're transmitting back and forth. Obviously, there are HIPAA implications, but HIPAA is actually OCR, Office of Civil Rights. Again, that's under HHS as well. But that surprises a lot of people.
Yeah, it's incredible. But it's not very practical for like sites. Like, no, you're never going to run across this. Most likely.
Well, think about how your data is being transmitted and the like, right? So it might really be a sponsor issue primarily, unless the site creates discrepancies. Here's a really basic question, and so, I don't like raising this question because no one really knows the answer to this question.
Those are the best ones for podcasts.
Yeah, I guess, but as an attorney, I don't want to be asked this question. Is information given as part of research subject to HIPAA?
So I believe, well, I asked a few big companies, like publicly traded, huge.
Sure.
And they said no.
I'm sure they said no.
As long as they're 21 CFR Part 11.
That has nothing to do with Part 11 compliance. Has nothing to do with data privacy.
Well, maybe they quoted something else. They quoted something in CFR with the electronic systems and limited access and
That's part 11.
Okay, so that's what they quoted then.
But so part 11 really goes to the fact that it's permanent and you can't get rid of data. But that's not the same thing as data security and data privacy.
So like
and data security is different from data privacy.
So like data leaks.
Data leaks and stuff like that. That's not covered under part 11.
So I've been told the new trend, I'm not going to name companies, but the new trend now from these tech companies is, yeah, you can actually upload patient medical records to your eSource or your eReg, and as long as you're restricting access to who gets it, you don't need to take measures to de-identify the patients.
Oh my God. I'm not even going to touch that. That's a paid consult right there. And I would not. That's
I mean, it's in their SOPs, and these are like dozens of companies. It's not just like one or two. This is like the new standard, like the new norm.
Here's the issue with that.
You're never going out of business.
Did the patient consent to this? Like, let's start with the really basic.
That's what they say. The patient consented. In the consent form, there is like these clauses now, where your data will be shared only with parties, right? So that's assuming there's no leak. Because if there is a leak, then
let's assume no leak. Let's assume no leak, right? Yeah. So let's start from there. So now we assume that the data, we went away from PIs, but this is always a fun conversation.
Yeah.
But let's assume no leak. The patient has consented that it'll be given the data will be shared with individuals who are conducting research. Let's say that's what the language says.
Yes.
In that scenario, people who are conducting research would include the site, would include the IRB, might include the... now, I don't know if you've tried to ever submit patient data to the IRB. They will refuse that as much as they possibly can. So they think it's subject to HIPAA. Now, they don't want you sending them patient PPI or PHI.
Like medical records, yeah.
Right. So you already have a conflict between what the IRB sees and the sponsor sees. In the context of whether it's PHI or not.
Right.
Then the CRO will see it, but when was the last time you had your CRO sign a BAA?
Well, never. They don't.
Exactly. Well, that's my point. So
you assume they have internal things that they sign.
No, but that's not what covers a BAA. A BAA is covering the CRO to the site. Internal has nothing to do with what's happening externally here.
So your advice for sites is, hey, no matter what anyone tells you, redact patient records before uploading them, just to be on the safe side.
That would be ideal, but then the question is, how do you identify the patient? How do you know you're doing it for the right patient?
I don't know. I mean, date of birth, right?
Maybe, but then that's still PHI, isn't it?
Nah, what can you do with a date of birth and a diagnosis?
You'd be surprised. Do you know how much information it takes to identify any person in the world right now? It's 3 bits of information.
Idea. I just got an email that my Social Security was on the dark web. So
yeah, my Social Security's been on the dark web for I don't know how long.
I think they just do that as a fear tactic to get you.
No. I am positive I could find my Social Security number on the dark web. Like It wouldn't be that hard at all. Yeah. But I can't live in fear is what it's come down to at this point for me.
All right, fair enough. But this stuff's complicated.
Right.
Okay, I might have our staff just redact our records again. I always thought that was the right thing to do, but then I'm like, you don't really have to. As long as they stay here and it's like e-signed.
Yeah, but so we didn't quite finish that analysis. So we went, okay. So you uploaded this record that the sponsor now has access to, which the sponsor specifically says, I will not sign a BAA because we're not subject to it. I've negotiated this with multiple sponsors who will basically disavow, do not send me PHI because I'm not signing your BAA because we are not a HIPAA covered entity.
They're not like sponsors are not.
Most sponsors refuse to become a HIPAA covered entity.
Why?
Because the amount of effort it takes. I did helped a company, a brand new company. Like I'm talking about, they started from zero. So I constructed every single thing. We got it up to being quote unquote basic HIPAA compliance It was a 1-year process, cost $200,000. There were no legacy systems, nothing to worry about.
I mean, sites don't do any of this stuff.
Exactly. This is why you need to be careful.
I see.
The
And who audits this? Who regulates
OCR,
this?
Office of Civil Rights. The
I
penalties can be in the millions. Ask your insurance company what they would charge to give you insurance for data security.
Right. So the advice for sites is always err on the side of caution.
Yeah.
No matter what. You are told by your CRA, your sponsor, just like old school. I think it was a lot more simpler in the old days of paper. Like, hey, we were taught Sharpie out
Yeah. Yeah.
anything.
Yeah.
Right. Now
Yeah.
it got a little more like willy-nilly with the EMRs and well, this one's okay. I know when I monitored, because I have the background of also monitoring. Like
Yeah.
I dabbled.
I remember.
Yeah, so I would go to universities, like prestigious places, and
Yeah.
they would just give me patient records like
Right.
to look at.
Right. And had you ever signed a BAA or anything?
Nope.
Did the company sign? Did you sign a
Nope.
confidentiality agreement with the company?
And
Did you get training?
the CRO that contracted me said, "Hey, make sure you scan all documents
Right.
from your visit." And then I didn't have a scanner, so phone,
Right. And how secure is that phone?
it's not. And
Exactly.
so it got me thinking, well, this is like prestigious
Right.
university, right?
Right.
It must be okay.
Exactly.
And I guess that's a big mistake because
Yeah.
what we're learning is these prestigious universities, either they don't.
I mean, there was Duke that,
here.
in the context of research misconduct, Duke, I think, paid like $180 million fine. Stanford just did this. I forget what their number was. My point is, prestigious universities are prestigious because of the type of work they do. It doesn't mean that their processes are completely clean. No one, multi-billion-dollar corporations are not completely clean. And they're taking, all of these companies are taking efforts to be compliant, but it's really, really, really difficult to do that.
Yeah, I guess just err on the side of caution. I mean,
Yeah.
it'll help me revise our SOPs. Actually, our SOPs say, the right way to.
The question is not whether the SOPs say, do you do it? Is a real
Do
question.
you do it? Yeah. Well, the good thing
fact,
about our
systems, if your SOPs say something and you don't do it, you have a violation. You have a deviation.
Right. No, I know. You can actually go and redact the documents within these systems, so it should be relatively simple. Okay.
But let me take one more. Let me finish the analysis there a little bit.
Mm-hmm.
If you the redaction and the like, but the tech companies want you to upload this data, right? That's what we just said. Here's my question.
These tech vendors,
right? In those scenarios, why do they want you to do it? Because they get access to that data, and then they get to use that data, for example, to train an AI.
Yeah, that is not good because that that's like in perpetuity right there.
The question then becomes: when the patient gave the consent, they gave it for research to the entities involved in the research. Did they ever actually give up ownership, or did they only give up the data to the extent necessary for research?
Right. I see. Another issue is these that no one's really talking about, and this is why you'll never go out of business, or people like you, are these tech vendors, like patient-reported outcomes, right?
Yep.
I've had this is your show. You got to tell people it's not legal advice. I have nothing, no license to lose. I've had same year, 2 different studies.
Yeah.
Same tech vendor for PRO, patient-reported outcomes. One sponsor insisted, do not put patient phone numbers or emails in this thing, right?
Yeah.
That was a European sponsor.
Yeah.
The other one, blue-blooded American sponsor, said, no, why would you not put the patient email in here? How do we know it's not fraud? How do we know it's not you doing their surveys for them?
Right.
Both have like valid points. So We just do what we're told.
Well, also, one is subject to GDPR, the other one isn't.
Sure.
GDPR is like the fines. Do you know what the penalties for GDPR are?
I know California does it too, no?
So California has what's called CCPA,
Okay.
CPRA, and now there's CMEA as well.
As long as not
And they're looking at new ones.
straight up CCP. That's different. Not to be confused.
I think that's CCCP, I believe. I
Ah,
thought it was 3 C's, but yes.
only 2.
Is it 2? Okay.
Yeah.
Huh. Okay. Interesting.
They have all kinds of laws.
Yeah, they do. That also doesn't exist.
That's right. But we just do what we're told. But the whole point of this sites, like sponsors pay us.
Yeah.
And we do what we're told.
Yeah.
And then if we get in trouble, though, this is the problem. Like, we're held responsible, not the sponsor. I mean, sure, they're probably held responsible too, but this is why you need someone like Darshan. Hey, man, we ran into some issues. Help get us out of this, right? That's basically what you deal with.
Yeah.
Regular basis.
That's my bread and butter. Yeah.
Who calls you more, sites or sponsors or CROs?
All of the above, but
Like,
it depends on different things. Yeah, for the most part. I think it's for different things. So sponsors will call up to basically go, I need to get a research program in place, negotiate my agreements. Am I subject to any compliance issues? CROs will call up saying, negotiate for me, negotiate with the sponsor for me, negotiate with the site for me. Every so often, tell me a little bit about privacy considerations, etc. And then the site will call me saying, can you be our HRPP, Human Research Protection Program officer? Can you actually negotiate contracts with me with the CRO or the sponsor? Will you respond to research misconduct allegations that I'm facing as a PI or as a site? All of those come up for me. And other issues, obviously. But the idea is I can see it from all the different sides. So then I can go, here's what they're thinking. Here's how we need to address this. Because I was thinking that when I was negotiating that agreement.
I see. All right. So then, I mean, ultimately at the site level, it boils down to PI oversight. All these issues, right? Like if you have a HIPAA compliance issue, that's PI. If you've got a protocol, GCP, that's PI. Everything's PI.
So here's the funny thing. I've actually been in situations where you've got delegation logs and the PI is delegated something.
They all have a delegation.
Yeah, my point being the second sentence, which is in the delegation log, the PI has a delegation. And I'm going, do you see a problem with that?
I do. I've had a study like that where like the PI is like on the log also. And it makes
Why is that a problem then?
It makes no sense because he or she is supposed to do everything.
He or she does the delegating.
Exactly right. Yeah. Exactly right. Yeah.
So the point we're making is that sites need to understand what they're saying. Just because you put a name on there doesn't make them like what they were trying to say is responsibilities, except the PI is responsible overall anyways.
Right.
If you're telling me that your PI is not allowed to do something, that would be terrifying because the PI is responsible for the whole thing.
Right. But the PI, here's a good example. IATA, right? Processing and shipping dangerous goods and substances or biological, not just dangerous. PIs are never on that because they don't have IATA cert and they don't do that. So, they're not there, but they are responsible for how it's done at the site, but they're not the ones doing it, nor are they allowed to do it.
Right.
Unless they were to get IATA certificate, which no PI in their right mind is going to do.
Right. But here's my question. Would that be considered to be part of research?
Well, yeah, because it's processing labs for a study that you're shipping out. Like, you have to.
Well, it comes down to the definition of PI responsibilities. And I'd have to look back at the guidance. I don't know if shipping of products is considered to be PI responsibility.
I think it's packaging and then signing the air bill. Packaging and signing the air bill. So like the one who verifies how much dry ice is in this box,
right?
And then you have to sign it.
Right. So that might be the endpoint, your door. is the endpoint of your responsibility.
Mhm.
The IDA certification would go farther than that.
Mhm.
And you're responsible to look at more and audit and all those good things from there.
Yeah, I think FedEx must have got audited by someone because they're used to just not care when you drop off shipments with dry ice, and
Yeah.
now they'll weigh it. They'll ask you like, "Is this how many kilogram?" Oh, they don't match up.
Right.
Or they even asked me recently, "Is the person who signed this air bill IATA certified?" They never used to talk like that before. So something must have happened at FedEx. You're not involved in
So,
this?
well, so what's been happening in general is that there's a lot of like import-export scrutiny
Mm,
for mislabeled drugs and adulterated drugs coming into and out of the country.
mhm.
So I don't know specifically what happened in that context, but
I think you're
it,
missing out on a good client, man. FedEx. Yeah, that's not a bad client to have, Darshan.
yeah, I wouldn't say no to them. I I think I agree in general, which is PI oversight plays a role. So we agree with you,
Well, yeah, PI oversight is the role.
Ingrid.
Everything else is up for debate, Ingrid. You're right. The interesting stuff's like, well, what and then what?
Yeah. So this was a fun conversation because we really tried to focus on PIs, but landed up talking a little bit about health tech. But we should probably do another one of these. I can talk a little bit more about the other fraud issues we're seeing. Maybe talk a little bit about ORI because
Yeah, no
most
one
people
knows
don't
anything
know
about
about
it.
ORI.
I think that's the first time I think heard about it. Who knows?
Yeah,
If you're on
yeah,
LinkedIn, you see all kinds of stuff, and you don't remember what you saw. So
yeah.
same difference.
There's just too much information being thrown at you. You've got to pick and choose what you're going to do a deeper dive into.
Well, and site owners need to stay pragmatic. Like, not everything's really important, unless Darshan tells you it is.
Well, reach out to me and I'll tell you.
Yep.
But before we go, Dan, and I know this is going to get onto your podcast as well. How can people reach you?
You know how LinkedIn, Instagram, TikTok, Twitter, whatever you guys want, YouTube. Get the book. Email Darshan and ask them how do I get a hold of Dan. Those are my
Absolutely.
favorite ways to get contacted.
Perfect. Dan, thank you again.
Thank you, Darshan.